Also, one of the individuals who did the phone download of the defendant's phone is going to testify very briefly today about the fact that he did the download and just a little bit about what he discovered. Most of that's coming in through the lead investigator. Obviously, the phone hasn't come up in testimony yet, so to the extent that there's any sort of, some of the stuff from the phone's already come in, so I don't think there's going to be an objection to not having laid the proper foundation because no one has testified about taking the phone from the defendant yet. I don't think there's an objection to that, but he's another one that we have to get in because of conflicts. So just putting that on the record, I think we're okay there.
Any issues from defense counsel's perspective with that? I don't have any issues, but if you have any, let me know. All right, that's fine.
The other issue that Mr. Scully and Ms. Strazik mostly have been talking about this morning is the defense has let us know that they plan on putting in all of the text messages between Ms. Church and the victim between November 1st and his death. It would be the Commonwealth's contention that those are generally hearsay and not admissible. But there are a number. I mean, we're talking a sizable number of text messages there. I expect that those would have to come in through Trooper Williams, who's going to testify on Tuesday. So that'd be an issue that's got to be dealt with. I mean, it doesn't have to be, but I think it might save us a lot of time if we deal with it before then.
Well, that's one of my issues. So I very much want to deal with that in advance. Is that correct, Mr. Scully? You believe that you would attempt to admit those texts through that particular trooper on Tuesday?
Yes. And just for a little credit, we have been going back and forth with hundreds of emails and redacting old stuff and getting on the same page everywhere we can. This will be one of the differences, and I thought it might come up today depending on how deep Commonwealth was going to go with this witness who did the download. Was he also going to be deep into other text messages, images, and so forth? He's not going deep. He's just going to this one area, I think, of these videos that Judy Church had taken of Mr. Fowler that we heard about when he was at her house around the time of the 911 call. So a long way of saying, as a result of that, I've decided not to, try to bring in these things through this trooper who may never have seen them, save them for Mr. Williams. And as a preview, I think that the primary reason that the defense will submit them and submit that we should be able to question the trooper about them and then also introduce them as exhibits is this is part of the Bowden defense. Maybe the real core of the Bowden defense is that and you've heard this in opening and suggested through some other witnesses and at sidebar, is essentially that the police took some preliminary statements primarily all on one day in one place with the family members of Leroy Fowler and focused their investigation exclusively on Judy in sort of warp time and seized her cell phone. She wasn't arrested when she seized her cell phone. She had come in and given a voluntary recorded statement. They took her phone on that day, so they had it to search. And later, when they went to the grand jury to present this case, what was revealed on the phone that we think is very relevant is that from November 1st until the phone is taken from her in her interview, which I think was November 14th, there are text messages throughout that show a very loving and positive relationship in November, which cuts against the grain of the Commonwealth's motive that she would want to kill him. There's the conversations about going to Florida, moving, packing, and then on the night of November 11th, they text each other all night. The texts are very kind of sexually graphic, but the gist of it is Leroy's in the back room sending sexual messages to Judy, who is responding kind of all night long about how those are good messages and good ideas that he's having.
Well, I think I've got the gist. I'll want copies of the text so I can review them over the weekend.
I think that makes sense.
I've got the gist of why you say they're admissible in pursuit of a Bowden defense. I'll hear from
Yeah.
the Commonwealth, who's objecting to the admission of most or all of the texts. But I will have reviewed them and had a sense of them, so we can have an informed conversation outside the presence of the jury about these and take our time, and I make my rulings, which is exactly how I want to deal with these things. So I appreciate that counsel have been exchanging these texts and exchanging their views, and we can vet the issues outside the presence of the jury.
And there's just one more thing that I think will help the court, is that we also view this as kind of very much tied into the particular presentation at the grand jury in this case, which was just the one witness, Trooper Williams. He testified substantively for about 23 pages worth of a transcript, which is in the court file under the motion to dismiss. And we can provide another copy along with these text messages to help with the Bowden analysis. None of the phone information that we say now was exculpatory and contrary to the gist of the grand jury evidence presentation was submitted. However, they did present basically the evidence that they're presenting at trial. Sorry, I don't have a cold. I just have something in my throat. But they did present like the statements that they've attributed, via Tammy Carbone, via Leroy, the ones they're going to bring in via Michael Hawkins. The other evidence that they're bringing in was really summarized by Trooper Williams sort of succinctly throughout the grand jury. And in our opinion, what was left out was, all of this other evidence that they had. And they didn't submit in any form, including there were no exhibits presented at the grand jury.
Well, we'll have that discussion. I will tell you, just so you know, my preliminary view on that is that we are not going to be litigating an Odell motion in front of this jury. And what you're talking about in terms of the grand jury presentation sounds exactly like an Odell motion. So normally, the fact of the indictment is neither here nor there. As I've told the jury over and over again, it's merely a formal accusation. It has no evidentiary weight. So I am skeptical about the propriety of introducing evidence regarding what was presented to the grand jury to secure the indictment. But we'll have that discussion.
And it's not Odell, and we're not raising this in an Odell perspective or the legal framework or arguing it. It's the way we're presenting it or trying to present it now to this jury is evidence of bias, that the police were had a one-track mind at that point. Didn't have an open mind, may not have even done the work and looked at our text messages. I don't think that they had.
The fact that the Commonwealth proceeded to a grand jury to secure an indictment against Ms. Church for first-degree murder shows that she was the person they'd focused on. Again, I'm skeptical that what they put in and didn't put in the grand jury is appropriate subject for evidence before this jury, but we'll have that discussion then. I at least understand it. I'll take a look at the text and then we'll have that conversation.
Excellent. Thank you, Your Honor.
Anything else, Mr. Strasnick, anything else from the defense perspective? Is that all you wanted to tell me, Mr. Scully?
I think that's all, yes. We would need I think the clerk has certified copies of medical records that might come in today.
Mr. Scully, they are right up here on the table. I notified counsel.
Okay.
Yes.
That's all.
Mr. Narkunis?
Judge, the only other thing, and I hadn't, we had subpoenaed in under 279 the medical records from his personal doctor, Mr. Fowler, and I think they would just come in through that alone. But I believe that the son would talk about he may have taken him on occasion to his doctor, and then I'm not going to cross-examine him on them, but I just thought get them into the record, I would introduce them. I don't have to today, but I could do it.
Normally, if the records have been certified and come in, they can be marked as an exhibit, again, subject to redaction, because I think there's always things in medical records that need to be taken out.
Need to get that through him.
Any issue with that, Mr. Camilio or Ms. Strasnick?
I mean, that doesn't matter when they get marked.
Yeah. Okay. Ms. Strasnick, you had something?
Just a couple things. When we were here on Wednesday, there was Exhibit 5 was entered by defense counsel, but only a portion of one of the text messages was...
Two words on the text that followed what the Commonwealth's exhibit texts.
What I did was I redacted that. I was able to make it on one text. I don't believe there's an objection to replacing this redaction.
So single exhibit that now contains that response by Ms. Carbone to the last text that was in the Commonwealth's original exhibit.
Correct.
So we substitute this version for that one that was marked. That's acceptable to me.
And that's by agreement. Thank you, Your Honor.
Thank you.
That was exhibit 5. Can you do one more exhibit? Can you do a sticker for 5, please?
And then I don't know if this should be marked for ID.
Why don't we do that?
We can.
And then I have two more little things.
Okay.
So the former number 5 will be marked as F for identification. That is. Did you mark that? Okay.
And Mr. Norkunis, you have the medical records in your hand? We can have those marked as well.
5 has now been so marked.
They would come in as an exhibit.
Yes,
8, correct?
subject to redaction.
Our next exhibit is 8.
That's medical records.
So marked.
Ms. Strasnick.
Thank you. Today we're going to be playing the first interview in time of the defendant. We've agreed upon the redactions. I'm just seeking to introduce the unredacted interview 1 as well as interview 2 unredacted as identification, just so the record's complete, and then we'll do interview 2 next week, the redacted version, once we agree upon that.
All right, so for identification, the unredacted 2 recorded interviews of Ms. Church.
Oh, is that marked
This
for
is
ID?
ID only.
ID, okay, that's G.
And then
That's okay.
my last thing at the moment is during the motion in limine regarding the text messages between Leroy and Tammy, Your Honor had gone through the 16 pages and indicated which ones would be, with Barb and Leroy, which ones would be admissible for his present condition and which ones you believe would be relative to the prostate cancer. I have taken the 16 pages and made them into, I believe, 4 with the redactions. I left the text message with Barb, but took out the content just so you could see that there was a conversation, but not the hearsay statements, and I don't believe that there's an objection. They don't need to be marked, but I don't know if the court wanted to review them. They'll be marked next week, just to make sure they're consistent with your order.
I would appreciate that. So if I understand you, the responses, which I didn't view a single response as shedding any real light on the true declarant's statements, but you just leave that so they know that there is some response in between that, which makes sense. That's a good way to do it.
It just seemed a little weird to just have the responses, and then what I did was I put the 2 relative to the prostate cancer on separate ones, just because I know the court was still considering it.
All right.
But they've been provided to defense.
Okay. So I will take a look at those. We'll finalize that, but I appreciate those efforts.
Right. We appreciate those efforts as well, and they look to be accurate. I did have a chance to review them, and for the most part, we would just have already made our objections and note them for the record.
I will, because, yes, I made some rulings, and you objected to some or would object to some, so that's fine. Your rights are preserved.
Thank you, Your Honor.
Yes, why don't we? Thank you.
You're welcome. These will be marked as H for identification.
If that concludes what counsel needed to discuss, I just want to see counsel at sidebar very briefly to discuss my matter, and then